Following the release of Special Counsel Herr's report, both the Judiciary and the Oversight Committees issued subpoenas requiring Attorney General Garland to turn over the transcripts and audio recordings of Special Counsel Herr's interview with President Biden and his ghostwriter, among other information. To date, Attorney General Garland has failed and refused to produce these audio recordings.
A desperate search to find something, anything, that they can use to damage President Biden and to protect Donald Trump.
We, as members of the House of Representatives, have a duty to ensure congressional subpoenas are fully complied with by those who receive them, people, companies, and particularly the federal government.
And in fact, it has been admitted over the last 2 weeks that there are differences between the transcript and the audio that they will not release.
They have good reason to believe that the Republican leadership on the Judiciary Committee would alter the transcript.
The American people deserve the ability to see that and make this decision on their own. They are sick and tired of being lied to.
Hopefully they didn't disappear like the cocaine at the White House. Hopefully they're still in existence.
This resolution upholds the institutional power of the House by recommending that the House find Attorney General Merrick Garland in contempt of Congress for failing to comply with the Judiciary Committee's subpoena. It's very simple. Attorney General Garland holds information vital to the committee's legislative oversight and the House's impeachment inquiry. Attorney General Garland has refused to comply with the committee's subpoena, and only belatedly did President Biden invoke an invalid executive privilege assertion over the audio recordings. Special Counsel Robert Herr stated on page 1 of his report, quote, "Our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen," end quote. Joe Biden not only kept information he wasn't allowed to keep, he also shared it with people who weren't allowed to see it. He shared that information with his ghostwriter. Special Counsel Herr stated on page 231 of his report that President Biden, quote, "had strong motivations to ignore the proper procedures for safeguarding the classified information in his notebooks. He decided months before leaving office to write a book," end quote. A book for which Joe Biden received an $8 million advance. But all this, and Special Counsel Herr declined to prosecute President Biden because Joe Biden is, quote, "a sympathetic, well-meaning, elderly man with a poor memory," end quote. Following the release of Special Counsel Herr's report, both the Judiciary and the Oversight Committees issued subpoenas requiring Attorney General Garland to turn over the transcripts and audio recordings of Special Counsel Herr's interview with President Biden and his ghostwriter, among other information. To date, Attorney General Garland has failed and refused to produce these audio recordings. To determine whether Special Counsel Herr appropriately carried out justice by not prosecuting the president, the recordings are necessary. The transcripts alone are not sufficient evidence of the state of the president's memory. This executive branch has a history of changing transcripts. In late April, during a public speech, President Biden read a teleprompter instruction to pause. He stated, quote, "Imagine what we could do next, 4 more years, pause," end quote. But when the White House put out the transcript, it didn't include the word pause. In that case, and in this case as well, the video and audio recording is the best evidence of the words that President Biden actually spoke. The department's refusal to produce the audio recordings of Special Counsel Herr's interviews with President Biden amounts to a demand that the committee trust the department created and produced interview transcripts are accurate and complete. Following the issuance of the subpoenas, and despite repeated follow-up from the committee, the department continued to withhold the audio recordings of those interviews without providing any constitutional or legal basis to do so. And then hours before the committee was set to meet and consider this contempt resolution, the department notified the committee that President Biden had asserted, at the Attorney General's urging, no less, executive privilege over the audio recordings. This belated assertion of executive privilege fails for numerous reasons. First, President Biden has already waived any potential assertion of executive privilege over the information discussed in his interviews with Special Counsel Herr by releasing the transcripts of those interviews to the media. Similarly, during Watergate, a federal district court held that President Nixon had waived any claim of executive privilege over certain audio recordings of his conversations because he had already published transcripts of those conversations. Second, President Biden's assertion of privilege is not valid because it is more than 2 months late. Any privilege should have been asserted by March 7th, 2024, the subpoena return date. Third, President Biden has not set forth any valid reasons for invoking executive privilege. During these interviews, he was not receiving advice regarding the execution of his presidential responsibilities. Rather, he was sitting for an interview with a special counsel investigating whether he mishandled classified documents while he was a private citizen. Fourth, the law enforcement concerns set forth by the executive branch lack merit and are outweighed by the committee's need for the audio recordings. There is just no reason to believe that individuals will be substantially less likely to cooperate with department investigations of both an interview transcript and audio recordings are produced to Congress, as opposed to just the interview transcript. The department has a legal obligation to turn over the requested materials pursuant to the subpoena. Attorney General Garland's willful refusal to comply with our subpoena constitutes contempt of Congress. Our oversight and impeachment responsibilities are too important to allow Attorney General Garland to willfully and unlawfully disregard our lawful subpoena. With that, I yield back.
Sure. Thanks, gentlelady. The gentleman from New York, Ranking Member Nadler, is recognized.
Thank you. Mr. Chairman, the Judiciary Committee under Republican control has spent the last 18 months and $20 million taxpayer dollars in a desperate search to find something, anything, that they can use to damage President Biden and to protect Donald Trump. Other committees have gotten into the act as well, spending untold taxpayer money not to benefit the American people, not to feed hungry children, not to address our housing crisis, not to improve our health care system, but on a single-minded quest to follow every right-wing conspiracy theory in the vain hope that it might lead to some evidence of wrongdoing. And what exactly have they delivered to the American people on their investment? Nothing.
This is not a complicated matter. The executive branch and its agencies, including the Department of Justice, are not above Congress's right to oversee those agencies. We, as members of the House of Representatives, have a duty to ensure congressional subpoenas are fully complied with by those who receive them, people, companies, and particularly the federal government. My colleagues on the other side of the aisle constantly talk about the threats to our institutions, but then they turn around and defend the DOJ's noncompliance with a duly authorized subpoena showing their partisanship. If my colleagues will not defend the institution of Congress, the institution they are a part of, how can we listen with a straight face when they talk about the sanctity of our other institutions? The President has asserted executive privilege over these audio recordings. Legal scholars find this assertion bizarre and meritless. The President has waived any executive privilege over these audio recordings by releasing a transcript of the entire interview to the public. When the transcript was released, President Biden's own White House spokesperson claimed, quote, "In keeping with his commitment to cooperation and transparency throughout this investigation, the President declined to assert privilege over any portion of the report," end quote. My question to the White House is, what happened to cooperation and transparency? What reason does the White House have to inappropriately assert executive privilege now? The White House has shown it is willing to alter transcripts to protect Joe Biden's image. It is insufficient to simply take the Justice Department at its word that the transcripts have not been altered.
There's plainly no basis for holding the Attorney General of the United States, Merrick Garland, in contempt, unless we're going to start holding people in contempt for complying with the committee's demands. This is actually the third witness who has faithfully cooperated with the Oversight Committee that the chairman has now threatened with contempt, the first being FBI Director Christopher Wray, the second being Hunter Biden. So this is the third time, and again, it makes no sense. Attorney General Garland and the Biden administration have consistently cooperated with the demands made by Chairman Comer and Jordan for information relating to Special Counsel Hur's review of President Biden. The Attorney General released the Special Counsel's report on President Biden in full. The DOJ made Special Counsel Hur available for multiple hours of testimony an examination before the Judiciary Committee, and he answered all of our questions.
If there's this much energy being placed to put a wall between the American public and the substance of these, the transcripts of these, I'm sorry, the audio of these interviews, clearly there's something that they desperately want to prevent from going to the hands of the American people.
Did I answer the question?
Mr. Burgess, I would say something in response to that. If they don't exist, I would say that someone has actually destroyed evidence. And that would be a very serious concern if someone actually did something with those audio tapes. I also think it's very important that we clarify some of the testimony that has been provided, which is there is the repeated claim that the transcript and the audio are identical, and that's not true. And in fact, it has been admitted over the last 2 weeks that there are differences between the transcript and the audio that they will not release. And it's one of the reasons why we absolutely have to have that audio, because they are not identical, and anyone who claims to the contrary is being disingenuous.
The basic reason the department doesn't want, I think, the basic reason the department doesn't want to release the transcript is because they have good reason to believe that the Republican leadership on the Judiciary Committee would alter the transcript, as they did with the Nina Jankowicz matter. She told us that in her deposition of April 2023, the Judiciary Committee altered, by cutting and pasting, altered the meaning of what she had said. And I assume that's the reason that the Justice Department doesn't want to release the transcript. I would also point out that, you know, the Republicans are claiming that the DOJ waived the ability to claim executive privilege by producing the written transcripts. Legally, that's simply wrong. Audio recordings have distinct features and law enforcement uses. Release of audio would have a unique chilling effect on future DOJ investigations. That Mr. Herr, who was a Republican, who used to work for Bill Barr, conducted a thorough investigation and found there was no basis for charging the president with improper retention or mishandling of classified documents, whereas, of course, the special prosecutor has indicted former President, or got a grand jury to indict former President Trump for mishandling classified documents, and he will have to go to trial. So it's a world of difference, and we should not be...
I'm going to interrupt you there. It is a world of difference because President Trump was president. These documents were procured when the Vice President Biden they were under his control. He did not have the same ability as the president to declassify and move these things.
I'm not going to debate that with you. I will simply point out that the special prosecutor, Mr. Herr, found no basis for indicting Mr. Biden, while the special prosecutor, Mr. Smith, persuaded the grand jury to indict Mr. Trump.
By your own admission, Mr. Nadler, you said that Mr. Herr's comments when he related the status of this interview was that the president seemed well-meaning but confused. Now, I think, and you said yourself, you characterized that. I think the American people deserve the opportunity to be able to hear that for themselves. People are smart. They can make that discernment on their own.
His report made very clear that there were multiple reasons for not indicting Mr. Biden. His gratuitous comment about Mr. Biden's...
I'm sorry, I'm going to interrupt you. I'll give you a chance to respond, but you're characterizing that as gratuitous is in and of itself gratuitous. I mean, you do not get to have that.
You can judge that. I don't think it's gratuitous. His comment was gratuitous because, if you read his report, that's not why the president was not indicted. There are ample reasons given in the report for not indicting the president. And given that, not including that, and given that fact, to make that observation was gratuitous.
Well, why not then clear the air and make the actual audio of the interview available? Let the American people be the deciders here.
Because...
Why hide that from them?
Because...
People are sensitive because they were told that, say, a certain laptop was Russian disinformation, and 51 members of the intelligence community signed a letter to that effect, and then it turns out, well, maybe it was not.
Because the chairman of the Judiciary Committee has already been caught altering,
May I respond?
no,
Yeah.
not until I finish, has been caught altering verbal, electronic transcripts in the case of Nina Jankowicz. And we have every reason to believe, or let me retract that.
Yeah.
We have no reason to believe that he wouldn't do so again.
Yeah,
If I may respond.
please, I wish you would.
That is absolutely untrue. Neither Jim Jordan nor anybody on the Judiciary Committee made any changes to Nina Jankowicz's interview transcript. That's absolutely a false statement.
On to
I will
Mr.
agree with Ms.
McGovern.
Hageman that there is no evidence that the transcript was altered whatsoever. The transcript wasn't altered. But in Ms. Hageman, I'm sorry, Ms. Jankowicz's case, the transcript wasn't altered, the video was altered. And that's what we're concerned about.
We're not arguing the Jankowicz case, we're arguing.
No, but if the Judiciary Committee
The American people
was
deserve the
dishonest
ability
enough,
to see that and make this
if
decision on
this-
their own. They are sick and tired of being lied to
if the,
by agencies.
if the
Mr. McGovern,
Judiciary
you're
Committee was
recognized.
dishonest enough, the leadership, to manipulate the video in the Jankowicz matter, it is dishonest enough to manipulate the video in this matter, and that is a good reason to withhold it.
You know, I think that there's only one question that we have to deal with here, and that's one question only. Can the executive branch ignore a subpoena that's not only lawful but valid? That's the one question we're here to decide. Everything else is just a complete distraction. Chairman Comer, would you like to talk about that?
I mean, look, we are the congressional overseers of the executive branch. We have checks and balances in our system. That's the way it was set up. And we have requested these audio recordings. The reason that we stumbled upon President Biden's mishandling of classified documents throughout the Biden influence peddling investigation was there were emails on the laptop that we now know was 100% legitimate because that was the major piece of evidence in the court case that Mr. McGovern cited a dozen times, it seemed like, in the last 30 minutes. There were emails on there that looked like they could potentially be classified documents. And the thing that the investigation has revealed is with the tens of millions of dollars that the Bidens have taken in from our adversaries around the world, there was never a business purpose. You know, they say, the media will say, or the Democrats say, well, in Hunter Biden and Jim Biden, or Joe Biden's business dealings. What business was it they were in? Because we haven't ever found a legitimate business. The business, according to at least two people who testified under oath, and that would be Bob Alinsky and Jason Galanis, was they were and three, counting Devin Archer, three former Biden associates said the business was selling the Biden brand.
The fact that the decision not to prosecute President Biden was because of the demeanor that was seen on the tape, and
That is
and
not
there was an
true.
assessment.
That
they
is
said-
not true. If you read the report, there are many reasons cited for not, for the decision not to indict. And I mentioned a few of them a moment ago. There are many reasons cited, and I think it's a 231 or 261-page report. And that's why I called the comment about the president's cognitive ability gratuitous, because that was not any one of the major reasons given in the report for declining to indict.
It's my understanding that one of the major reasons was that, and it was in the report, is that President Biden would present to a jury, as I believe the quote was, a well-meaning, I forget the exact word, but basically that he doesn't know what's going on. He doesn't
I recommend you read
have.
the report and see all the other reasons why they declined to indict.
But
in particular, the cooperation that I just mentioned, that it was President Biden's personal counsel who found the documents and at the Penn Biden Center and voluntarily reported them to the FBI.
Okay, but again, it was the demeanor and how he would present to a jury that he'd be sympathetic, that people would think he doesn't have control, mental acuity enough, and
Let me say this.
Hold on, we got to, Mr. Adams, we
Not
got
to
to
say
talk.
this. I don't want to get into a
We
debate.
cannot talk over each
I-
other.
I-
Gentlemen, suspend. The clerk cannot keep up with us when we
I'm sorry.
cross-talk. So let's one at a time.
okay.
Let
Go
me
ahead.
say this. That quote has been used and may have been put there, for all I know, to question the president's cognitive ability. I don't know why he put that in. But the fact is, there are going to be 2 debates, and the public will be able to judge the president's cognitive ability, and for that matter, the former president's cognitive abilities. There's no point debating it here.
It's really more a question for you, because you make an interesting point. You assert that whatever privilege the president had, and obviously that was something that was expansively invoked by Donald Trump, but you're saying if he had an executive privilege, it was waived when he turned over the written transcript. But does that argument depend on the written transcript being a faithful transcription of the oral statements? If so, it would seem to defeat the point. I mean, let's say if they're really different, then he's asserting executive privilege, presumably, for the 0.001% of it that hasn't been turned over yet, right?
So I get what you're saying, but I would say that if the transcript is different, that's all the more reason to get the audio or the audio visual of it, so we can see if the transcript meets the audio visual. But the fact, are you implying that the transcript was doctored?
No, but that's the paranoid theory that's been floated today by some people. But no, I think that's ridiculous. In other words, I think those 2 arguments cut against each other. The idea that the privilege has been waived depends on the idea that the written transcript is actually a faithful record of what was spoken. And I haven't seen any evidence, certainly, that there's any difference in the 2. So, you know, I think we are really splitting hairs here. I mean, it's kind of an amazing thing that we would think about holding the Attorney General of the United States in contempt for not giving the audio version when we have all these people walking around who've never given any testimony at all in answer to subpoenas, and it doesn't seem to trouble, you know, at least your side of the aisle.
No, I get your argument, but I mean, again, if you've already handed over the transcript itself, I would still argue that you've already waived the privilege of then holding on to the audio visual of the transcript. I mean, that's just my understanding. I understand you're saying we're splitting hairs here, but Ms. Hageman?
Yes, a couple of things. To conflate the outcome of the 2 cases between Hunter Biden and President Trump is an absolute absurdity. It's also an absurdity to claim that the outcome in one case with Hunter Biden being convicted today is reflective of the viability or legality of what happened in New York is also absolutely absurd.
I would like, however, to, the gentlelady from Wyoming a moment ago said that there were clear differences between the way the Hunter Biden trial was conducted and the legitimacy of that trial and the illegitimacy of the Donald Trump trial in New York. Maybe she'd enlighten us as to the difference?
I'd be happy to, but I do not understand why that would be at all relevant to the discussion that we're having today. But I'm happy to have that debate with you any day of the week.
Please.
But I just don't think that that's relevant to what we're discussing.
Well, you brought it up, so
I mean,
why don't
we
explain
can
it?
start with
You said it was absurd.
Wait, hold on, Ms. Hageman.
All
Ms.
right,
Hageman.
we can start with the judge that was handpicked rather than randomly chosen, which is typical in most of your court cases. You can talk about the fact that you talked about unanimity of verdict. We don't even know what the verdict was at this point in terms of what he was allegedly convicted of unanimously. We can talk about the fact that almost every single ruling that was made by Judge Merchan in New York was against the defense, despite the fact that when you're dealing with a criminal case, there's either typically much more of a balance or, in fact, to ensure that the prosecution actually meets its burden of proving beyond a reasonable doubt, most of the rulings would be in favor of the criminal defendant, not in favor of the prosecution. It's in the fact that the expert witness, who is the former head of the Federal Election Commission, was excluded from testifying as an expert witness in the case in New York, despite the fact that he has been qualified as an expert witness to testify on these matters throughout the entire United States. It is the fact that there were other witnesses that were excluded. There was substantial evidence, prejudicial evidence, that was admitted during the course of the trial. And then when you look at what happened with Hunter Biden, the prosecution was very precise, very specific about the nature of the statute that was at issue and how he violated it. And then they brought in the evidence from the family members, the ex-wife, the girlfriend, the Beau's widow, the young girlfriend, all of the testimony, him reading the book, all of the testimony. The evidence was overwhelming. that Hunter Biden had violated the specific statute at issue. So there's dramatic differences in terms of how the New York case was handled versus how the case against Hunter Biden was handled. If you'd like to spend another 3 or 4 hours, we can go outside and I can give you additional evidence to that effect.
Was the subpoena duly issued?
Yes, ma'am. Yes, ma'am.
Did Attorney General Garland ignore that? Or-
Yes.
So that's what we're talking about today.
Yes,
That's
ma'am.
should be our laser focus,
That's why I'm here.
and I appreciate that. Because I think if you're tuning in for bits and pieces of this, you miss the whole point that we have one thing in front of us. And I will tell you, I was interested when when I came in and Mr. McGovern said this is a waste of time. But I remember sitting on that side of the desk, and 3 or 4 times we had rules like this holding someone in contempt.
So if he doesn't have it, or if he's destroyed it, that's a serious, or if they alter it or omit or whatever they do with it. But are you comfortable, I mean, you or Mr. Comer, do y'all feel the tape still exists? Because they're going to a big extreme to defer and try to prevent the American people from hearing it.
Well, all I can say on their behalf is I sure hope so.
Mr. Comer, Mr. Nadler, I'll get to you. Let me just.
It's my hope and it's my understanding that they still exist. Hopefully, they didn't disappear like the cocaine at the White House. Hopefully, they're still in existence and haven't been destroyed.
Okay, Mr. Nadler, do you have a choice? Well, I want you to answer this question. If you were subpoenaed, do you have a choice not to comply with the subpoena?
You do not, unless the president has asserted executive privilege, and then it's got to be decided in court. What I wanted to comment on was what you said about the trial in New York. The trial was conducted by a New York County prosecutor in New York County because it was a violation of state law, not federal law. Now, he may have violated federal law too, but that wasn't alleged.
But I'll reclaim my time, but the two of you on the Democratic side have acted as if that conviction in a very limited jury pool would be the same as conviction. If it had been in a federal court, the jury pool would have been pulled from 8 counties in that. Would you at least agree with me that if it had been in federal,
yes.
it would have been 8 counties?
Yes, I would
Okay,
simply
and would you
observe-
agree with me there's a difference in pulling from a jury pool of 8 counties and pulling from one that, you know, even.
I would simply point out that the defense had every opportunity to exercise its challenges in the voir dire, and that the 12 jurors who were picked were ultimately agreed upon by the defense and the prosecution.
That's, you know as well as I do that that's a, when you're agreeing to something from bad to worse, you know, I mean, President Trump didn't have a chance with that jury pool. And the bottom line is this: he's going to be President Trump again,
Maybe.
and that's why y'all are so scared of him, and that's why y'all are going to great lengths. I personally, Mr. Chairman, I don't think we need the audio tape. I think every time Joe Biden goes on TV, we see what Mr. Hur concluded. He's a well-meaning elderly man that probably doesn't have his wits about him, and with that, I'll yield back.
He's not talking about sharks and electric
Chair, thanks,
boats.
the gentleman.
I'm sorry, I didn't hear that. What was that, Mr. McGovern?
He's not talking about sharks and electric boats.
I don't think he knows what he's talking about.
That was Trump, by the way.